how can we reduce the backlog of cases? How can we reduce the pendency? How can we take away the burden of the apex court? Now, coming to the another suggestions, ad hoc appointment of retired judges under Article 128. Because whenever we discuss about the backlog of cases in the Supreme Court, the pain that is expressed by the people are Supreme Court judges, and the Supreme Court is closed for vacation. We have summer vacation for 1.5 months. We have winter vacation for 15 days, and you have holy holidays for a week. Thereafter a week holidays for Diwali. Therefore, they express their grievance. The vacation should be curtailed. But Honorable Supreme Court judges, they are overburdened. We cannot even feel their burden. Reason is, consider Monday and Friday are generally considered to be the admission matters, and nearly 50 to 60 matters are listed before the court. So judges has to read 50 briefs. We find it difficult as an advocate. We find it difficult to read a single brief. Judges, they need to read 60 briefs. And SLP, 60 SLPs in a day. That means they need to read 1,000 pages. So that is the story of Monday and Friday. And think about Tuesday, Wednesday, Thursday. Final hearing matters listed. Miscellaneous matters are listed. Nowadays, few admission matters are also listed. And think about Saturday and Sunday. They have to, whatever the cases that they have heard, they need to pronounce judgments. So they need to go through the written submissions. They need to go through the SLPs once again and come and render judgment by dictating to the stenographers. Thereafter, give it for circulation to the brother, his lordship. So the Saturday, Sunday are also spent on judgments. Then again they need to read yet another 60 SLPs that are coming up on another Monday. So they are completely occupied. They cannot even lift their head from the SLP paper book. This is what Justice Indu Malhotra her lordship said in the Friday group at library number 2. So considering those vacations, number of holidays that they go for, even Supreme Court lawyers also, the answer to that question is, we can have retired Supreme Court judges, those who are residing in Delhi, we can ask them to occupy during the vacations, and the Supreme Court can have an effective functioning as that of a normal court. The provision is also there under Article 128. Only thing is, ad hoc retired judges has to be appointed by the Supreme Court, by the Chief Justice of India, with the approval of President of India. And this article was put to test. An interesting story was there. In the year 1972, when the Keshavananda Bharati case was heard by 13 judges, the retired judges were taken back to the court, like judges' names are C.A. Vaidyanathan and His Lordship Justice I.D. Dua, D.U.A. They were brought back to the Supreme Court and they were made to sit along with the newly appointed judge, Justice A. Alagiri Swami. So they were occupying the bench and deciding cases for some couple of months. But only thing is, the disturbing factor is, the retired judges were already seniors to the newly appointed judges. But after their retirement, if they were brought back to the Supreme Court, they lose their seniority. Newly appointee sit as a presiding judge and retired judge, he sits as a brother judge. So he loses his seniority. But again, this article can be explored and we can put to test and we can make the retired judges to come to certain terms and we can utilize their rich experience, their rich knowledge in law for getting timely justice. So this is my another option. And thereafter, fourth option is when we draft SLPs, SLP has got a format. List of dates and events, synopsis, list of dates and events, then impugned judgment, then SLP with question of law and grounds, and then prayer. I would like to propose, like list of dates, like synopsis, there can be one more page added to it. The page can be named as amicable settlement page. How we call synopsis, list of dates, there can be amicable settlement page. In that, the petitioner can say that this case can be settled subject to the respondent agreeing to certain terms and conditions. If that is there, then Supreme Court, while considering the petition, they can issue notice on the settlement page also. If the respondent also agrees to the terms, then immediately matter can be decided then and there. I got this idea by my own experience. My experience goes like this. There was a transfer petition filed by one lady before the Supreme Court seeking transfer of a petition which was pending before the Family Court Madras to Family Court Bangalore or any other state. The ground which she took was the Family Court judges were biased because the respondent is a wealthy man, influential man. Therefore, I wanted a transfer from Madras, Family Court Madras to Family Court Bangalore. When the matter, I appeared for the respondent. When the matter came up before the Hon'ble Supreme Court Judge, His Lordship immediately posed a question to the advocate for the petitioner. This transfer petition was filed a year back. Now the situation could have changed in the family court because there might have been a change in the judges. Therefore, your petition has become frivolous, and the petitioner has made unnecessary allegation against impartial judge. These were the observations made by the Hon'ble Supreme Court judges. Immediately, the advocate for the petitioner understood the mindset of the judge and immediately said, "My lords, your lordships may refer the matter to mediation. Therefore, we mediate, and there are number of cases pending between both of us. We will settle it." So the case was referred to mediation, and mediation took place for 2 times. Mediation failed and yet to see the light of the day before the Hon'ble Supreme Court. So from this, what I would like to submit before you all is understanding the mindset of judges, thereafter asking for matter to be referred to mediation is something that tactics, delaying tactics. Otherwise, if the case was decided then and there, could have been dismissed. So, to avoid the dismissal, the amicable settlement terms was introduced by the advocate for the petition. As per my humble submission, if the amicable settlement page was put up already In the be it SLP, be it transfer petition, in the first page, the respondent could have given a reply to the terms. If settlement failed at the first instance, then they would have decided, the Supreme Court judges could have decided the case on merits. So the delaying tactics would have been avoided. So therefore, this amicable settlement page can be introduced as the first page in every petition. Therefore, the settlement terms will not crop up in the midst of the arguments. And finally, we are running short of time, and there are questions to be asked also. So now the last and not the least, my humble submission is, strength of the judges should be increased, because a lot of pending cases now they are overburdened. So if you increase the number of judges, the number of cases will also be disposed of at the earliest. But those who want to criticize the number of judges to be increased, they have a point to say. If number of judges are increased, there will be a divergent opinion on certain question of law, and it is very difficult to adhere to the judicial discipline. Though every concept has own advantages and disadvantages, we have to ignore the disadvantages and we have to take the advantages. To my knowledge, there are no prescribed limit for taking adjournments through letter circulations. We can put a limit. Therefore, unnecessary and frivolous adjournments can be unnecessary and frivolous adjournments can be avoided. Now, we have seen, going back to all these 4 questions, we have seen the evolution of justice. We have seen whether the timely justice is the heart and soul of the Constitution. We have seen, are we getting timely justice? And we have found the problem is backlog of docket, explosion of SLP, and we have come out with certain suggestions. And let me come to the 5th final question is, what we have gathered out of this presentation. What is the conclusion? What is the fruit of this presentation? What is the moral of this moral story behind this is? I would like to say that humbly. Timely education will save the mankind. Timely monsoon will save the crops. And timely medical treatment will save the life. And timely justice will save not only the victims but also the institution where the large number of people expects and believes, has enormous faith in this system. And I would like to conclude my presentation with the quotation of Swami Vivekananda. Swami Vivekananda said, take up one idea, make that one idea your life. Think of it, dream of it, and live on that idea. Let your brains, muscles, bones, nerves be full of that idea and leave all other idea alone. This is the way to success. From this, I take the guidance. The success of the judicial institution will be, our only concept is timely justice. We cannot attribute the timely justice to be rendered only by the judges, but also all the stakeholders. Timely justice should be our idea, and for which we all should work for it. And with this, I conclude.